Your last topic for this morning is about the 2009 new DARAB rules of procedures. We have the 1989, the 1994, the 2003 DARAB rules of procedure, and now the current and still applicable is the 2009 DARAB rules of procedure, which we will tackle and discuss for the remaining 1 hour. So we have until at least 12:15 to discuss the 2009 DARAB rules of procedure. Pero please be informed that the secretary already signed, and all the board members already signed the 2020 DARAB rules of revised DARAB rules of procedure, and it's now with the Farm RS in our Farm RS for publication. We know fully well that until it is published, and after the lapse of 10 days from publication, that's the only time that it will take effect. So in the meantime, while it is not yet effective, we will focus on the 2009 DARAB rules of procedure. But don't worry, because most of the principal doctrines, the general principles, and most of the provisions under the 2009 DARAB rules of procedure are retained or maintained under the 2020 DARAB revised rules. As we will discuss the 2009 rules, we will take up some of the major amendments. So, as all we know again, under Rule 1, the DARAB rules shall be liberally construed to carry out the objective of the Agrarian Reform Program. And we are not in the DARAB governed by technical rules of procedure. That is why even the rules of court is not applicable, even in suppletory character. And if there is doubt, we must resolve the doubt in favor of the beneficiary or our tenants, agricultural lessees. Now, under Rule 2, jurisdiction, so we will devote most of our time on the jurisdiction of the board and the adjudicators. So, under Rule 2, jurisdiction, but before that, let us take a look on the historical background in the disposition of agrarian cases. Before long time ago, in 1955, June 14, 1955, the jurisdiction to adjudicate or to resolve cases involving farmers and landlords was under the power of the Court of Agrarian Relations. That was in 1955, 1 year after the enactment of Republic Act 1199. Republic Act 1199 is our Agricultural Tenancy Act. So before any disputes arising from RA 1199 were under the jurisdiction of the Court of Agrarian Relations. Now, that jurisdiction of the Court of Agrarian Relations under RA 1267 was maintained also under RA 3844, and in fact in chapter 19, in chapter 9 of Republic Act 3844, which took effect in 1963, that law created Court of Agrarian Relations in the entire country. And after the amendment of 1199 and RA 3844 by RA 6389 in 1971, subsequently in 1974, next slide please. Next slide again. Next slide. Ayan. In 1976, after the amendment of RA 1199 and 3844, in 1971, RA 6389 amended 1199 and 3844. But please take note that 6389 did not totally repeal RA 1199 and RA 3844. So after that, 5 years after that, PD 946 was issued by then President Marcos. Under PD 946, the courts of agrarian relations were reorganized and their procedures were streamlined. So under Section 12 of 946, under paragraph A, the courts of agrarian relations were given the jurisdiction to adjudicate issues involving the rights and obligations of farmers on lands lands under their cultivation. And then in paragraph B of PD 946, it also gave the courts of agrarian relations the jurisdiction to adjudicate rights and obligations of farmers or parties involving laws on or PDs on agrarian reform program. However, while PD 946 gave courts of agrarian relations the jurisdiction to adjudicate disputes involving rights and obligations of our farmers, not only on their lands under their cultivation, but also involving the rights and obligation in the implementation of the program. But those issues involving the strict implementation of the program, which at that time is PD 27, and there is no CARP yet in 1976. So those issues involving the administrative implementation of PD 27 were given to the Secretary of the Department of Agrarian Reform and not within the jurisdiction of the Courts of Agrarian Relations. So if you will notice, even way back in 1976, during the enactment of PD 946, the jurisdiction in the disposition of agrarian reform cases was already twofold. Within the jurisdiction of the courts of agrarian relations, and the other one within the jurisdiction of the Secretary of the Department of Agrarian Reform. And what are those issues or cases involving the administrative implementation at the time of PD 27? So number one, those involving the classifications and identifications of land holdings. Number two, identification of tenant farmer and landowners, and the determination of their tenancy relationship. But please take note that this tenancy relationship that the determination of this tenancy relationship is only for the purpose of determining whether the ARB is qualified and whether the land is covered under PD 27, because one of the elements of PD 27, the land must be tenanted. And then number 3, parcellary mapping, a determination of total production and value of the land, and then issuance recall of CLT, right of retention, and then right to home lot, and then disposition of the excess area in tenant land holding, and then change of crop from rice or corn to any other agricultural crop. So conversion, issuance of certification for the conversion, transfer, surrender, or abandonment by the tenant farmer, and then increase of tillage, and provided that the decision of the secretary is appealable to the office of the president. What can you notice under the jurisdiction of the secretary of DAR under PD number 946? So those identified cases or issues under the jurisdiction of the secretary under PD 946 are almost the same cases known for us under the ALI rules as agrarian law implementation cases. So all our agrarian law implementation cases are the same as those enumerated jurisdiction of the secretary under PD 946. So as you will notice, twofold. Since 1946, the jurisdiction is already twofold. If rights and obligation, it at that time belonged to the courts of agrarian relations. However, if administrative implementation, at that time of PD 946, it remained with the Secretary of the Department of Agrarian Reform. After PD 946 in 1976, on August 14, 1981, our Batasan Pambansa passed Batas Pambansa Bilang 129, which reorganized the judiciary. And then the jurisdiction of the courts and relation under PD 946 was transferred to the regional trial court, and all courts of agrarian relations were integrated into the regional trial courts. That's why, if you will notice, that some of the decisions of the Supreme Court, all decision on cases, you will notice some were originated from the courts of agrarian relations, court of first instance, and then the regional trial court. But now with the passage of EO 229 on July 22, 1987, the jurisdiction, the inherited jurisdiction of the regional trial court from the courts of agrarian relations was transferred to the Department of Agrarian Reform under Section 17. What is Section 17? This Section 17 is the quasi-judicial power of the DAR. The DAR is hereby vested with quasi-judicial powers to determine and adjudicate agrarian reform matters, and shall have exclusive original jurisdiction over all matters involving the implementation of agrarian reform, except those falling under the exclusive and original jurisdiction of the DENR and Department of Agriculture. So, DAR under EO 229 was given a quasi-judicial power. Now, in the case of Nina Quismundo versus Court of Appeals, the landowner, the tenant of the landowner here, the tenant of Nina, filed the case before the regional trial court for the change of their relationship from shared tenancy to leasehold tenancy. We all know that shared tenancy is already outlawed because it is against public policy, and all shared tenancy under 1199 uh, uh, automatically and by operation of law shall be converted into leasehold tenancy as provided for under RA 63 89. So that's why the tenant of Nina filed a case before the RTC for the change of their relationship. Nina filed a motion to dismiss on the ground of lack of cause of action. The RTC denied the motion to dismiss, but in the motion for reconsideration of Nina, he added additional ground, the lack of jurisdiction of the court, because according to Nina, the regional trial court pursuant to section 17 of EO 229 has no more jurisdiction. It's now with the Department of Agrarian Reform. The RTC denied the MR, the motion for reconsideration, and the Court of Appeals affirmed the RTC. That's why Nina elevated the matter to the Supreme Court through a petition. Now, according to the Supreme Court, the issuance of EO 229 already divested the regional trial court of its jurisdiction under PD 946, and that jurisdiction was transferred to the Department of Agrarian Reform because of its quasi-judicial powers under Section 17. So RTC, in the case of Nina Quezmundo versus Court of Appeals, has no more jurisdiction on agrarian reform matters. And according to the Supreme Court, in that case, with the enactment of Republic Act 6657, which the quasi-judicial power of DAR under Section 17 of EO 229, Section 56 and Section 57 of RA 6657 delimited or limited the jurisdiction of courts on agrarian reform matters. So what is Section 56? Section 56 is the mandate of the Supreme Court to designate in each judicial region at least one regional trial court to act as a special agrarian court. And then what is Section 57? Section 57 is the jurisdiction of the special agrarian court. And according to the case of Nina Quezmundo, with the grant of quasi-judicial powers in favor of the Department of Agrarian Reform, the jurisdiction of courts, especially or particularly the Special Agrarian Court, was limited to only two kinds of cases. Number one, the just compensation cases, and number two, the cases involving the penal provision of 6657 under Section 73 and Section 74. But please take note of RA 8435, which penalizes the commission of premature conversion, which in my opinion can also fall under the jurisdiction of the Special Agrarian Court. in the case of Rupina Viuda de Tango versus Court of Appeals, the petitioner in the Supreme Court, Rupina, allegedly and claiming to be the tenant, filed a case against the landowner before, again, the regional trial court for dispossession of tenants. And she prayed that she should be reinstated as tenant. But the RTC dismissed that case on the ground of lack of jurisdiction. The Supreme Court again said the court has no more jurisdiction. It's now with the Department of Agrarian Reform. So twofold jurisdiction. So when the Department of Agrarian Reform rendered judgment on involving rights and obligation of parties under 1199, 38, 44, 63, 89, and under the program PD 27 and 6657 as amended, through the DARAB, it is an exercise by the DARAB of its quasi-judicial power. But when the DAR rendered decision in an alley cases or in an alley case or in alley cases by the secretary, DAR is exercising its administrative function. That is why the decision of the DARAB can be elevated only to the Court of Appeals in accordance with the rules of courts, whereas the decision of the secretary can be elevated only to the president in accordance with the administrative code of the Philippines. So twofold, quasi, DARAB, and then administrative disposition of alley cases through the secretary. There are those who are of the opinion that the secretary, in rendering decision in alley cases, is also actually exercising quasi-judicial function. That is the opinion of the other DAR officials, but I don't agree, because later we will discuss it. Why quasi-judicial is through the DARAB and administrative through the secretary. After EO 229, President Aquino issued EO 129-A, reorganizing and strengthening the DAR. Under Section 13, EO 129 created the Department of Agrarian Reform Adjudication Board, to be composed of the secretary, two undersecretaries as ex officio members, and then as the assistant secretary as ex officio members, and then the three regular members to be appointed by the president upon the recommendation of the secretary. So what are the powers and functions of the DARAB under Section 13? The board shall assume the powers and functions with respect to the adjudication of agrarian reform cases under Executive Order number 229. So very clear that the quasi-judicial function of DAR under EO 229 in resolving agrarian reform matters, that powers pertain to the DARA, to the Department of Agrarian Reform Adjudication Board. Please take note of the case of Eugenio Bautista et al. Versus Villena. It is not in the it is not included in my PowerPoint. The case of Eugenio Bautista et al. Versus Villena, GR number 152564, GR number 152564, September 13, 2014. In the said case, it was held that in the process of reorganizing and strengthening the DAR, EO 129A was enacted. It created the DARAB to assume the adjudicatory powers and functions of the DAR under the DARAB rules pursuant to EO 229. So, in my opinion, quasi-judicial powers uh, exercised by the Department of Agrarian Reform through the DARAB is an exercise of quasi-judicial function, whereas the rendition of judgment in early cases through the secretary is an administrative implementation of the program under PD 27 and RA 6657 as amended. That is why the decision of the secretary is governed by the administrative code of the Philippines and can be elevated only to the office of the president. But I respect the opinion of others that the secretary, according to them, is also exercising quasi-judicial power in the resolution of early cases. Ayan, so as I already explained, the twofold jurisdiction of the DAR in the disposition of agrarian cases, and I believe that it was also discussed to you by ASEC Jim in when he presented the ALI rules or the agrarian law implementation cases. Now, this is the organizational structure of the Department of Agrarian Reform Adjudication Board. So, adjudication board. Then we have the DARAB Secretariat, support staff of the adjudication board. The DARAB Secretariat is actually the clerk of the board. Then we have the regional adjudicator and we have the provincial adjudicator. So the board has appellate jurisdiction on decisions rendered by the regional adjudicator and the provincial adjudicator. The board has also original jurisdiction on cases involving the annulment of decision of the RARAD and the PARAD. The board also has original jurisdiction on just compensation cases if it involves an initial valuation of 50 million and above. The board has appellate jurisdiction the board has no appellate jurisdiction to review the decision of the RARAD or PARAD on just compensation cases. So the decision of the RARAD and PARAD can be elevated directly to the Special Agrarian Court through the filing of an original action, because under the 2009 DARAB rule, the board has no appellate jurisdiction on land valuation cases. This is a major amendment to the 2020 DARAB rules, because under the 2020 DARAB rules, the board was given the jurisdiction the appellate jurisdiction to review the decision of the regional adjudicator and the provincial adjudicator. And it maintained its jurisdiction on land valuation involving an initial amount of 50 million and above. So please take note of that changes in the 2020 DARAB rules. Now, we go to the regional adjudicator. The regional adjudicator exercises supervision over the parads and staff and monitors cases in the region. The RARAD acts in cases of inhibition and unjust compensation cases and other cases to be assigned by the board. Here's application for the issuance of a writ of preliminary injunction and or TRO as directed by the board and land valuation cases in excess of 10 million but not exceeding 50 million. There is an amendment in the 2020 DARAB rules. The jurisdiction of the RARAD from 10 to 50 million was amended to become only 3 million up to 50 million. Meaning, the jurisdiction of the parad involving an initial amount of 10 million below will be decreased to just 3 million and below. 3 million and up and above, but not to exceed 50 million is now within the jurisdiction of the RARAD. What is the wisdom behind the amendment? Because the board would like to give to increase the load of the RARAD, because we observe that parads have more cases, pending cases, have more load than the RARAD. So by decreasing the jurisdictional amount of the parad to just 3 million and below, we expect the increase in the load of the RARAD insofar as just compensation cases are concerned. So please take note of the amendment. So the jurisdiction of the parad under the 2020 rules below 3 million and below, RARAD 3 million up to 50 million, and the board it remains at 50 million above. And the board has now appellate jurisdiction on the decisions of the RARADs and parads on land valuation cases. Take note also that the RARAD has and the parad has concurrent jurisdiction to adjudicate issues involving agrarian reform matters. Now, let's look at the jurisdiction of the DARAB one by one. Number one, still we are still under Rule 2. The rights and obligation of persons, whether natural or juridical, engaged in the management, cultivation, and use of all agricultural lands covered by RA number 6657, otherwise known as the Comprehensive Agrarian Reform Law as amended, and other related agrarian laws. What is an example of this jurisdiction under paragraph 1? Example, there are many CLOA holders or EP holders who cannot possess the awarded lands given to them because there are some occupants. So what they will do, they will file before the DARAB a petition for recovery of possession, claiming to be the awardee, and they have the rights to possess the land. So the usual answer of the respondents, the occupants, is a lack of jurisdiction on the part of the DARA, because according most of the argument of the respondents, there is no tenancy relationship between them. So the DARA has no jurisdiction. So we usually grant the petition and deny the claim of the respondent that the DARA has no jurisdiction. We invoke our jurisdiction under this paragraph 1 of the DARA rules of procedure. Sometimes the respondents, the occupants, will file a motion to dismiss because according to them, they have a pending Ali case. I have one case. I decided it in favor of the CLOA holder, but without prejudice to whatever outcome of the Ali case, because I think, in my opinion, the filing of an Ali case or cancellation case to preempt the recovery, the getting of possession by the CLOA holders is just an afterthought. So I also deny that defense of the respondent. Number 2, jurisdiction of the DARA, the preliminary administrative determination of just compensation under PD 27 and CARP. So we already discussed it, the jurisdiction of the board, the RARAD, and the PARAD. Next slide, please. Number 3, those cases involving the annulment or rescission of lease contracts or deed of sale. Example, order amendments involving lands under the administration and disposition of the DAR or the Land Bank of the Philippines. Those involving the amendments or rescission of lease contracts of the deed of sale, order amendments involving lands under the administration and disposition of the DAR or the Land Bank of the Philippines, and the amendments of titles pertaining to agricultural lands under the administration and disposition of the DAR and the Land Bank of the Philippines, as well as EPs issued under PD 266, homestead patents, pre-patents, erroneous sale patents to settlers in settlement and resettlement areas under the administration and disposition of the DAR. Analogous to paragraph B and C. Please take note of the cases decided by the Supreme Court involving the annulment of deed of sale, annulment of title, because the transaction lacks the required DAR clearance. Please take note of the case of Pantoa versus Paramount, and then the case also of Pantoa versus Robles. In the case of Paramount, the Supreme Court said that DARA has no jurisdiction because there is no showing, there is no allegation that the land is under, that the land is covered under CARP, and in fact, the land subject matter of the case of Paramount is actually reclassified already into non-agricultural uses. But in the case of Pantoa versus Robles, the Supreme Court said the DARA has jurisdiction because there was an allegation that when the notice of coverage was about to be issued to cover the property under CARP, then the landowner sold the property without DAR clearance. So the Supreme Court said the DARAB has jurisdiction. And then jurisdiction of the DARAB involving cases uh, involving cases on sale, alienation, preemption, and redemption of agricultural lands under the coverage of CAR. I hope ASEC Annabel discussed to you the rights of the farmers under 3844 as amended by 6389, the right of preemption and the right of redemption. Take note of the RUPA case, wherein the Supreme Court laid down the 5 requirements for a valid exercise of right of redemption. Take note also of the case of Basbas versus Entena, and the recent one, Estrella versus Francisco. Those involving the correction, partition, secondary and subsequent issuances, such as issuance of lost, destroyed owners, duplicate copy, and the constitution of PROAS and EPs which are registered with the LRA. We maintain in the DARAB the jurisdiction of DAR on the issuance of second owner's copy, but we have a conflict of opinion regarding on this with the land registration authority, because according to LRA, only the regional trial court can order the register of deeds to issue second owner's copy. But as I had discussed before, when that was given the quasi-judicial power under Section 17 of EO 229, which was reiterated under Republic Act 6657, that grant of quasi-judicial powers to the DAR delimits the jurisdiction of the regional trial court to just only two cases, All other cases involving agrarian reform matters are within the jurisdiction of the DAR. So is the issuance of second owner's copy a case involving just compensation? Definitely not. Is the issuance of second owner's copy a penal provision under Section 73 and 74 of 657? Of course not. So if not falling within the jurisdiction of the SAC under Section 57 of RA 6657, then courts has no jurisdiction on the issuance of second owner's copy. Kaya lang ang ginagamit ng LRA is PD 1528, the Land Registration Act. According to the LRA, under that law, under that PD, only the artist has jurisdiction and not the DARA. But that law is a general law. Republic Act 657 is a special law. Also, PD RA 657 is the later law than PD 27. So in case of conflicts, statutory construction, special law shall govern, not the general law, with respect to the disposition of agrarian reform matters. And in my opinion, the issuance of second owner's copy is an issue involving the program. Kaya meron namang ibang Office of the Register of Deeds na ino-honor nila yung order or decision of the parad on the issuance of second owners. Pero may din naman mangilan-ngilan na hindi nila nire-recognize. So we have to sit down with the LRA to resolve the issue on this conflict of jurisdiction. Okay. Another jurisdiction of the DARAB, those cases involving the review of leasehold, rentals, and fixing of disturbance compensation. So our present AO on leasehold rentals is AO number 2, series of 2006. And take note of section 12 of RA 6657, requiring that to make an annual review of all leasehold rentals. And then fixing of disturbance compensation under section 36 of paragraph 1 of section 36 of RA 3844 as amended by Republica 6657. And then those cases involving the collection of amortization payments. So wala pa akong nakitang beneficiary na foreclose yung kanyang title because of non-payment of amortization. There is a pending bill in Congress proposing for the government to waive the payment of amortization, meaning free distribution of lands to farmer beneficiary. But that is still pending. But there is this Bayanihan Act 2, the Bayanihan Act 2, paragraph 4M. The government, the state is waiving the imposition of 6% interest on unpaid amortization. Paragraph 4M of Bayanihan Act 2, very clear that the waiver is on the interest regarding the amortization payments. But there are those who believe that it includes even the interest on loans given to the ARBs. The PRFC, the policy review and formulation committee of the Department of Agrarian Reform is now drafting our IRR on the implementation of paragraph 4M of Bayanihan Act 2. And those cases involving the ejectment and dispossession of tenants and leaseholders. So there are many grounds available for the landowner on how to eject tenants. Common is the non-payment of lease rentals, then abandonment, then subleasing, waiver of rights, failure to comply with the tenant's obligation under 657, under 3844 as amended. And I hope ASEC Annabelle discuss to you one by one those grounds. And then such other agrarian cases, dispute matters or concern referred by the Secretary of the Department of Agrarian Reform. So other cases which the Secretary may refer to the DARAB. Example of this case is the case of Lapanday on the annulment of venture agreement agribusiness venture agreement between the investor Lapanday and the CLOA holders. It was pending before the park, but the park, because of an opinion, DOJ opinion, that the DARAB has jurisdiction, then park referred it to the DARAB. So the DARAB can assume jurisdiction on cases, although Ali, but referred by the secretary or the park. Okay, next slide. So appellate jurisdiction of the board, we are done on that. And then the jurisdiction of the secretary. These are the enumerations of Ali cases. If you will notice, the same as those enumerated under PD, almost the same as those enumerated under PD 946. So those are under the jurisdiction of the secretary in the administrative implementation of the program. So the jurisdiction of the DARAB to cancel LOA was already transferred to the Secretary of the Department of Agrarian Reform. When Section 24 of 657 was amended by Section 9 of RA 9700. So DARAB has no more jurisdiction to cancel LOA. Now, jurisdiction of the Special Agrarian Court, just take note, Section 57. We discussed this already. Yeah, Modesto versus Uwalat, in this case, an ejectment case, unlawful detainer, was filed before the sala of Judge Ramos. Despite the insistence of the respondent tenant that Judge Ramos, the MTC has no jurisdiction because the DARAB has jurisdiction. In fact, the tenant in that case was represented by a DAR lawyer. Judge Ramos continued to assume jurisdiction. So an administrative case was filed against Judge Ramos, and Judge Ramos was administratively admonished and found guilty of found administratively guilty because of his refusal to dismiss the case before him for lack of jurisdiction. According to the defense of Judge Ramos, allegation in the complaint is determinative of jurisdiction and not the allegation in the answer. So he just followed the rules. The allegation of the tenant in the answer is not determinative of the rules. The Supreme Court did not admit that defense. According to the Supreme Court, if there is an allegation of tenancy in the answer, it is prudent for Judge Ramos to at least call for a preliminary conference for him to determine whether or not there really exists a tenancy relationship between the parties. Because if there's really a tenancy relationship between the parties, then he has no jurisdiction. It's only the DARAB, through the DARAB, can resolve that case. So, if you will remember, right before PD 316, yung referral law. So, if it is not proper for trial because there is an agrarian dispute, then no court shall take cognizance of a case involving the tenant. Then there is PD 1038. Yan. Yung PD 316 na yan, 1038 was repealed by Republic Act 657 under Section 76. So repealed, nawala yan. So what happened when PD 316 and PD 1038 were repealed. Dumami yung harassment cases against the tenant. Kaya when Republic Act 9700 amends Republic Act 6657 under Section 19, the referral, the Congress brings back the referral of agrarian dispute filed before courts. So under Section 19, no court or prosecutor shall take cognizance of cases pertaining to CARP. So yan, take note of .AO4 series of 2009, .AO3 series of 2011, and then the audio opinion number 40-10, and then OCA circular 62-10. Okay, next slide. Yan, I discussed already the case of Pantoja versus Paramount. Yan, Pantoja versus Robles. Now we go back to the DARAB rules. After Rule 3. So before you can file a case before the DARAB under Rule 3, there must be a certification from the BART that the parties undergone the process of mediation and conciliation. It's a condition sine qua non. However, the non-submission of birth certification is not a ground for dismissal because the parent can refer it to BART or can refer it to MARO or ARPT as the case may be. And there are cases where birth certification where birth certification are not required. Example, in just compensation, birth certification is not required when one party is a juridical person. The case was referred by the secretary to the DARAB, and absence of the BART, no BART constituted in the place where the property is located. So under those circumstances, no BART certification is required. So the action under Rule 4, the action before the DARAB can be commenced only by filing a verified petition or a complaint. So it must be accompanied, aside from the birth certification, by a certificate of non-quorum shopping. Now, there are also cases which can be initiated before the DARAB without filing a verified complaint or petition. Example again is just compensation cases, and in those cases referred by the secretary to the DARAB. In those two situations, it can the proceedings before the DARAB can commence even without the filing of a verified petition or complaint. Now, we all know that the parties in a case before the DARAB must be the parties having an interest on the subject matter, on the land subject matter of the litigation. And then proper litigant, the tenant may avail of the privilege of a proper litigant by alleging it in a complaint or motion without presenting any proof. And once granted, that tenant can continue to enjoy such status at all levels of the proceedings, even on appeal. And then the time to answer under the 2009 DARAB rules, 15 days. But please take note, in the 2020 DARAB rules of procedure, we reduce it to just 10 days. So we reduce the period of 15 days under the 2009 DARAB rules. In the 2020, we reduce it to just 15 days. The time to file answer, 10 days. The time to file a motion for reconsideration, 10 days. the time to file appeal memorandum 10 days, as well as to file appeal 10 days. So it's no longer 15 days, but 10 days. The wisdom or the objective is to make the disposition of agrarian cases more speedy. And then appearances, a non-lawyer can appear if he represents himself, if he represents a farmer, if he is a law student, and if he is a DAR legal officer. So preliminary conference, the parad shall have full control of the proceedings. And then he may schedule the case for preliminary conference to discuss again another another possibility of amicable settlement between the parties. So ito na naman another amendments in the 2020 DARAB rules. Under the 2009, there is no provision on virtual or online hearings. There is also no procedure on online filing. But in the 2020 revised rules, we provide provisions for online filing and hearing. And how to do it, we attach it as an annex to the DARAB new rules of revised rules of procedure. So prohibited motion, the same. All motions filed prior to answer prohibited. And then there is also no motion for extension of time to file appeal, to file MR, or to declare defendant in default. Those are prohibited motions. But again, in Rule 1, we said that we are not bound by technical rules. There are many MR at this time filed before us beyond the 15-day period, but we relaxed the rule. We relaxed the rule for a valid reason because of the pandemic. So though filed out of time, we still entertained MR due to the pandemic. And then Rule 12 intervention, and then so decision of the board, decision of the PARAD or RARAD must be appealed within 10 days under the 2020 DARAD rules. And if not, it becomes final and executory, except just compensation cases. Why? Because just compensation cases by the PARAD, RARAD, or the board, rendered by the board, RARAD or PARAD, can be elevated to the SAC, to the SAC by filing an original action for just compensation. Kailangan ba i-observe ang 15-day period before in the case of Philippine Veterans Bank? Yes. In the case of Lubrica, yes. But in the case of Suntay, the Supreme Court said the 15-day period did not be observed. Subsequently, in an en banc decision in the Martinez case, sabi ng Supreme Court, 15-day period as provided for under the DARAD rules must be observed. So adapting the Philippine Veterans Bank and the Lubrica case, in Lim Kai Chong case must be observed. But in the most recent case, in the case of the Lauta, the Supreme Court said the 15-day period need not be observed. The 15-day period need not be observed. Eh kung hindi i-observe yung 15-day period, until when the landowner can file a petition for just compensation? The Supreme Court said 10 years from NOC in the body, but in the dispositive portion, it said 10 years from taking. The landowner can still file an action, an original action before the SAC for determination of just compensation. In case of inconsistency or conflict between the body and the dispositive portion. The dispositive portion will prevail. Now, if there is already a pending case, a pending administrative determination of just compensation before the RARA of Parat, can the landowner go directly to the SAC without terminating the administrative case before the RARA? The Supreme Court said no, dapat ma-terminate. But can he go to SAC even not yet terminated yung administrative case before the SAC? The Supreme Court said yes. Now, petition for relief from decision. Take note of the period, 60 days from discovery of fame, and then 6 months from rendition of judgment, or 6 months from rendition of judgment. Now, under the leasehold, the order of the PARO under AO2 series of 2006 is immediately executory. Although immediately executory, any aggrieved party may go to DARAB by filing an action for either determination of the tenancy relationship of the parties, or for the correct determination of the leasehold rentals. Although the PARO order is immediately executory, the adjudicators under Rule 7 of the DARAB rules, as even in AO2 series of 2006, the adjudicators are given the power to issue an order for supervision of harvest. And in that order of supervision of harvest, may amend or may modify the executory nature of the order of the PARO in the determination of the lease rentals under AO2 series of 2006. And then under Rule 18, the DARAB has the power of direct and indirect contempt. So many, in the case of Listana, the Supreme Court said the DARAB has no jurisdiction on indirect contempt, but we insist that we put that in the 2009 DARAB rules, even in the 2020 revised DARAB rules, because of the grant of quasi-judicial power under Section 50 of RA 6657. And in fact, in the board, several cases involving indirect contempt, we decided, citing the respondent for indirect contempt. And let's see what the Supreme Court will say if the DARAB, if the Supreme Court will maintain its decision in the case of Listana. Now, execution, and then board regulation, and then the Rule 12 on the role of the executive director or the DARAB secretariat in the disposition of agrarian cases. I will end my presentation on the 2009 DARAB Rules of Procedure and some of the amendments in the 2020 revised DARAB Rules of Procedure. Thank you very much for listening. Thank you.